Good evening and welcome back to Particulars. I'm Lacey. I have a licensed PI firm here in the state of Indiana, and I am also a law student headed back to class this month. My bachelor's is in criminal justice with a concentration in forensic psychology.
And I'm Nick, former federal agent and a veteran. Everything you're about to hear tonight is fact-checked and verified as of 5:30 Eastern this afternoon.
Headlines in, the details begin. Tonight, 2 catch-up days in the Lindsay Clancy trial, a Las Vegas murder case where the defendant's own words have become some of the prosecution's most important evidence, a license plate reader that actually did its job, and a red flag out of Oklahoma we've been sitting on for weeks, waiting until the documents held up.
We're going to move on to our first segment of the night.
Trial watch.
Commonwealth versus Clancy.
Okay. So, if you're just finding us, Lindsay Clancy is on trial in Plymouth Superior Court, charged with 3 counts of murder in the deaths of her 3 children, Cora, 5, Dawson, 3, and Callan, 8 months, in Duxbury, Massachusetts, in January of 2023. Her defense is built around a specific legal standard called lack of criminal responsibility, tied to a claim of severe postpartum mental illness.
Now, lack of criminal responsibility, the Macau standard. Massachusetts' version of an insanity defense. The defendant isn't disputing what happened. She's arguing that a mental disease or defect meant she lacked substantial capacity to either appreciate the criminality or wrongfulness of her conduct, or to conform that conduct to the law. It comes from the 1967 case, Commonwealth versus Macau, 352 Mass 544. We pulled and read that opinion directly.
One more piece people consistently get wrong. A verdict on this ground isn't the same as simply being released. Massachusetts law GLC 123-16 allows the court to order hospitalization for up to 40 days for observation and examination after that verdict. So continued commitment beyond that requires a separate petition and separate legal findings about the person's present condition. It's a fundamentally different track from a prison sentence, but it isn't accurate to call the verdict itself an automatic permanent commitment.
Day 11, Tuesday, August 11th. We had no live show, but we're catching up tonight.
Correct.
We didn't air Tuesday, so before today, here's day 11. And it actually opened with a fight over a proposed defense witness. It traces back to Monday's testimony from Dr. Aaliyah Goodhart, who treated Clancy at McLean Hospital. Reddington said a prosecutor's questioning of Goodhart made McLean sound like, in his words, quote, some kind of 5-star institution, end quote, where clinicians were competing to treat Clancy, who was, quote, blithely refusing care, end quote.
So that characterization didn't sit well with Emily Thorndike, a licensed clinical social worker who used to work that same McLean unit. She posted a TikTok video disputing it directly, saying there's no one-on-one therapy on that unit, that a single doctor can be covering all 23 patients on a weekend, and that what prosecutors called one-on-one therapy was actually just check-ins from unlicensed staff.
Reddington moved to add Thorndike to the witness list. I'm making sure the audio's checking out. So Reddington moved to add Thorndike to the witness list. Prosecutor Shannon Buckingham objected, pointing out,
Shannon.
Is it Shannon?
Yeah.
Okay. Prosecutor Shannon Buckingham objected, pointing out Thorndike had been watching trial testimony, which witnesses normally aren't allowed to do, and that she'd separately called the prosecution of this case, quote, an abomination, end quote.
So Buckingham's objection isn't just about a bad TikTok take. A witness who's watched testimony can shape her account around what she's already heard, which is exactly why witnesses are typically sequestered from trial coverage. There's a real evidentiary problem, not just a prosecutor being annoyed online. So Judge William Sullivan didn't rule outright, but he wasn't subtle about where he's leaning. He suggested the defense find a different witness and said, someone whose time of clean actually overlapped with Clancy's stay and who hasn't watched the trial. His exact words, quote, "This is not TripAdvisor. I wouldn't allow that," end quote. I will also say on that, if you caught was it Monday night? I think it was Monday night. We briefly touched on that. Did anybody pick that up? And I will go ahead and say, because
You patted yourself on the back.
I did give myself a pat on the back because we discussed that before it even made.
Even People Magazine picked it up.
So I will say that's why we ask people to come and join us in the lives, because you get some of that sidebar.
Mm-hmm.
So you might hear something discussed before you see it, and then you can put pieces together. But anyway, later on day 11.
Separately, Tuesday, psychiatric nurse practitioner Julie Paul returned to the stand, continuing defense cross-examination from Monday. After she stepped down, Rebecca Gelada, a psychiatric nurse practitioner at South Shore Health in Weymouth, who treated Lindsay Clancy for several weeks, beginning in November of 2022, spent nearly the entire day testifying.
So on redirect, 88 Jennifer Sprague asked Gelada directly, in her experience treating patients with postpartum psychosis, whether they hear voices or not. Did anything in her contact with Lindsay Clancy give her concern that Clancy was suffering from it? Gelada said no. Defense attorney Kevin Reddington's response on the record, quote, "It appears as though she was, doesn't it?" End quote. The prosecution objected. Reddington withdrew the comment and said he had nothing further.
Now, that's Reddington's characterization in the moment, not a finding. He withdrew it himself, and it's the jury's call, not ours, what the evidence shows. We're reporting that it was said in open court. Sourced to CBS Boston's August 11th coverage and cross-checked against the day's proceedings, not asserting it as established.
I will say another one of those perks of being able to watch the full day of the trial and testimony, you do get to see a little bit of those moments, which it is hard to push as much out because it is, depending on if it's a full day of trial, etc., it's a lot of material to try to put into a short live.
Yeah.
So we do have to kind of pare down what we are.
Right. To put it into 20 or 30 minutes, it's
a lot.
6 hours of testimony into 20, 30 minutes is tough.
Yeah. So I will just say that. But that is our coverage for day 11. And we will move on to day 12, which is today, Wednesday, August 12th. Words are hard. We should make a shirt.
Yep. That's our next shirt.
Today, day 12, the Commonwealth kept moving toward resting its case. Letitia Dukes, a mental health counselor who was Lindsay Clancy's perinatal clinician at South Shore Health starting December 2nd of 2022, testified that Clancy reported intrusive suicidal thoughts and anxiety that something would happen to her children. Dukes also testified that Clancy did not show any signs of psychosis or mania.
The next part of today's testimony is difficult. We're going to describe it briefly and factually without dwelling on detail that doesn't serve understanding the record. If you need to step away for a moment, this is the spot. Dr. Renee Stonebridge from the Office of the Chief Medical Examiner examined the eyes of Cora and Dawson and the brain and the eyes of 8-month-old Callan. Findings, she said, were consistent with an asphyxial strangulation type death. The defense did not cross-examine. Lindsay Clancy cried audibly during her testimony, prompting a recess.
A second medical examiner, Dr. Barbara Olson, then took the stand. She's the one who actually performed the autopsy on Cora and Dawson. Walking the jury through autopsy photos, she described ligature furrows and other neck injuries and testified that Cora's cause of death was mechanical strangulation and Dawson's was asphyxia. Clancy's crying grew loud enough that Judge Sullivan called another recess mid-testimony. When court resumed, he reminded jurors to weigh the evidence and set emotional reaction aside. Reddington did not cross-examine Olson either. Court adjourned for the day around 4 p.m.
Now, quick context before the next exchange, because it's not actually new tonight. Buckingham raised the male voice claim herself in opening statements 3 weeks ago, telling jurors to consider the source, the timing, and the substance of the voice, and stressing Clancy has never claimed to hear it before or since. Reddington, in his own opening, got ahead of an argument the prosecution hadn't explicitly made yet, that Clancy only started claiming to hear that voice after she was examined by his own expert in the hospital. That's the same question that comes back up today.
So separately today, Massachusetts State Police Sergeant Dan Lawler, one of the officers who guarded Clancy's hospital room after her arrest, testified about a specific visit to that room. Reddington had obtained a court order allowing psychiatrist Dr. Paul Ziesel, or is it Ziesel? I can't remember. So to see Clancy. Lawler said the door was closed during that visit. It was apparently during that same visit on a phone call to Patrick Clancy that Ziesel let her make that Clancy first told Patrick she'd heard a voice compelling her to kill the children.
Reddington then asked Lawler directly, isn't it the prosecution's theory that Ziesel...
I just think of the commercial.
The owl?
Yes, and I think
Ziesel?
I think it's Ziesel,
Okay.
but for some reason that's all I can think is Ziesel.
Isn't it the prosecution's theory that Ziesel told her during that visit to call Patrick and say she'd heard voices? Lawler said that was his understanding. Prosecutor Shannon Buckingham pushed back hard, asking whether Lawler had ever actually discussed the prosecution's theory of the case with anyone from the prosecution. He said no, his understanding came from a conversation with the lead detective, not from prosecutors themselves.
So watch the chain here. This is defense counsel characterizing what he says is the prosecution's theory put to a trooper whose actual source was a detective, not the prosecution itself. So 2 of the 3 links in that chain aren't the prosecution's own words. We're reporting that this exchange happened in court today, not that it reflects the prosecution's actual theory of the case, which we haven't heard stated directly by prosecutors.
And this is worth sitting with, not because it proves anything, but because it's 3 layers removed from the prosecution's actual position. A detective's read, relayed to a trooper, characterized by defense counsel, testified to on the stand. Every link is a place the account could shift, like the telephone game.
I was literally going to say that.
Reddington himself got Lawler to agree there's no investigative basis for it, that it's the lead detective's speculation. That detective has a name now, Trooper Joshua McElligan. These Irish names. Trooper Joshua McElligan, per court filings in this case. Watch for 2 things going forward. Prosecutors clarifying their actual theory directly, and whether McElligan ends up testifying himself.
Yes. And from where I sit, you're now stacking several treating providers back to back, each describing the same window of time slightly different. That's not unusual in a case like this, but it does put a lot of weight on the jury to reconcile accounts that were never meant to line up perfectly in the first place.
Court resumes tomorrow morning. We'll bring you day 13 and whatever comes after it on Friday.
We will go on to our legal minute, and I am really going to date myself for our legal minute.
Yes.
The Tupac Shakur murder trial. Nearly 30 years after Tupac Shakur was shot and killed on the Las Vegas Strip, jury selection began this week in the murder trial of Duane Keffe Davis.
Keffe D.
Keffe D.
Yeah.
Okay, well,
or Keffe. Keffe D. It says pronounced Keffe D.
So the only person ever charged in the case. The trial is in Clark County District Court. Judge Carly Kearney presiding. Oh my goodness. Mark D. Giacomo and
Binu Palal
are prosecuting Michael Sanft is defending. Say all of those names 5 times fast.
These names are made up, I'm telling you. All right. Statute of limitations on murder. Most states, including Nevada, don't put a time limit on prosecuting murder. That's the short answer to why now. Legally, there was never a clock running out on this case. Here's what makes the case unusual. No DNA, no recovered weapon, no cooperating living witnesses. What prosecutors have is Davis's own words across 2 separate moments years apart that the defense tried to keep out of trial and lost both times.
So first, a 2008 interview Davis gave to federal task force agents under what's called a Proffer agreement, sometimes nicknamed a Queen for a Day arrangement. Judge Kearney ultimately ruled the 2008 interview admissible at trial.
Second, Compton Street Legend, the Davis memoir published in 2019, where he wrote in detail about his role that night. Kearney ruled back in June that jurors can hear about his gang history straight from the book itself.
So, really quick, we're going to break down what a proffer agreement is. So, Davis's 2008 interview wasn't a casual conversation with detectives. It was a formal proffer agreement negotiated with federal task force agents that promised the government wouldn't use that specific session as direct evidence against him at trial. So the fight in court wasn't over whether that promise existed. It was over what the promise actually covered and whether it survived Davis later choosing to repeat the same information publicly in a 2018 BET interview and then in the 2019 memoir. So prosecutors argued a proffer protects the statement made under its specific terms. It doesn't reach back to cover what someone later volunteers on their own. So for an audience outside that room, Judge Kearney agreed. So Samp's defense argument boiled down. The book was written to sell copies, not to confess to a crime. Entertainment, not evidence. Prosecutors are working to corroborate specific details in it against outside evidence instead.
And I've seen this pattern before in federal work. Someone talks their way through one exposure, then years later hands prosecutors a second one voluntarily because they wanted the credit or the money or both. Nobody made him publish that book.
Which parts of that book are true is going to be the entire trial. So prosecutors say it generally described the provable life of Davis, even where details are embellished. The defense says that that's exactly the problem. We're not litigating that here, just explaining why both the interview and the book are admissible at all.
It's entertainment for the masses. That's all this is.
So open discussion, okay? The defendant is also the star witness against himself, framing multiple outlets are using
Suge Knight.
I was going to say Suge Knight. Wounded that night and driving the car, is on the witness list, but has publicly said he doesn't want to testify. Jury selection expected to run about a week. Trial testimony starting around August 17th.
All right, let's move on.
Segment 3, evidence of the night. A license plate reader arrest, Laramie County, Wyoming, right?
Yes.
Okay.
Tonight's evidence of the night is a case where the same surveillance technology we've spent real airtime scrutinizing actually worked exactly as designed. In Laramie County, Wyoming, a warrant went out several weeks ago for a man on sexual abuse of a minor charges. He evaded arrest for weeks.
So Cheyenne Police Department detectives used automated license plate reader technology in northern Colorado, the same general category of technology we've covered before, including officers misusing it to stalk people to track down his vehicle. Fort Collins police made the arrest. Cheyenne PD says the entire process from renewed search to arrest took 48 hours.
One note on the technology itself. We're not naming a brand here. Our source describes it only as license plate reader technology, which are in the squad cars, and obviously we don't have primary confirmation of which system was actually used. And Fort Collins ended its own flock safety contract back in June. Don't assume it's the same vendor as our earlier coverage. Same category of tool, unconfirmed manufacturer.
Because of the nature of the charges, Cheyenne PD isn't releasing the suspect's name, and neither are we. So we don't have a case number or court docket yet. This is sourced to the department's own public statement reported by Cap City News and KOWB, not a filing we've pulled directly.
We've spent real time on this show on officers misusing this exact technology to stalk people. This is the other side of that coin, and it belongs right next to that coverage, not instead of it. The tool didn't change between those stories. The oversight and the use case did. That's the actual variable worth watching, not the camera itself.
There was actually, I think it was Florida. Was it the one that I sent you yesterday that was Florida?
Gainesville.
So there are continuing to be cases that are coming to light in regard to this.
Yeah.
I will
700 times.
I will say what I really want people to understand, that we cannot have the good without the bad. We can't have the bad without the good. We have to look at, which is why we are continuing to cover both types of cases, because if we are talking about the specific technology, go back up. If we are talking about one piece of technology, we should be able to have a discussion on how it can be a benefit and also how it can be misused, and try to figure out how we equalize that playing field, I guess, so to speak.
It's gonna take more oversight.
Quick tie back to episode 1, 6, and 8. So we have actually covered this type of technology, flock cameras, etc. We have several episodes that talk about this. So if you are wanting more information about this type of coverage, you can check those cases out. The replay is on YouTube. Segment number 4, the red flag, which is the Duffy Gilson Owasso, Oklahoma case. So tonight's red flag is a case we've been building quietly for weeks out of Owasso, Oklahoma. I cannot say Oklahoma. Sarah Gilson and Jeremiah Sean Duffy. We held this one back because the reporting needed real verification before it went on air. Tonight, we finally have enough to bring it to you, including one major update that resolves a gap we flagged as recently as our last episode. So
You want me to go on?
you can go ahead, yeah.
Sarah Gilson, also known as Sarah Duffy, was 43. Duffy was 48. The other Duffy, yes? Sean, Jeremiah.
Yes.
So Sarah Gilson, also known as Sarah Duffy, was 43. Jeremiah Duffy was 48. On June 9th, a parent and a minor reported to Owasso police that Duffy, who coached the girls' traveling basketball team, had inappropriately touched her during a team event at an elementary school. Another coach on the team witnessed it and reported it immediately. Police say similar conduct involving the same minor had been reported over an extended period across more than one jurisdiction. We are not naming the minor involved, and we're not detailing the specific allegations beyond that general description. That's not information that that public needs, and no editorial purpose is served by going further.
So we're going to define federal jurisdiction under the Major Crimes Act. So here's where jurisdiction becomes important. Police say Duffy was a member of the Osage Nation,
Yeah.
and that the alleged conduct happened in what's legally defined as Indian country for certain serious offenses committed by an enrolled tribal member there. The Major Crimes Act, 18 U.S.C. 1153, places criminal prosecution in federal court, exclusive of state courts. So per the Justice Department's own manual, that's why Owasso police said they referred the case to the U.S. Attorney's Office for a charge of lewd molestation of a minor, and said doing so was, in their words, quote, ending the jurisdiction of the Owasso Police Department over this reported incident, end quote.
That referral is genuinely useful. It explains why we could never find a matching criminal case in Tulsa County under Duffy's name. It doesn't tell us whether the U.S. Attorney's Office ever actually filed federal charges before Duffy's death. That part remains unconfirmed, and we're not filling it in with a guess. Police were also careful to note, this was an allegation, not a conviction. NBC News built an entire separate piece around this exact question. What happened in the 44 days between the report and the killing remains largely unclear. The authorities have provided few public answers about the sex abuse investigation itself.
So the same day the case was referred, police walked Sarah through how to get an emergency protective order. She did, granted June 10th, ordering Duffy to stay 100 yards from her and her home. In her application, she alleged Duffy had threatened suicide and left the area, according to the Oklahoman.
That wasn't the first protective order in this history. Sarah had filed 2 separate emergency orders against Duffy back in 2021. Both were dismissed after she didn't appear at the hearing. The record doesn't say why, and we're not going to speculate about the specific woman's reasons. At a general level, that pattern, a protective order filed and then dropped, is well documented across domestic violence cases broadly. That's a pattern worth understanding. It's not a verdict on this case. On July 11th, 12 days before her death, Sarah posted a video to her TikTok where she had a following in the tens of thousands, using a viral trend format built around a mock Netflix documentary interview. In it, she said she's just learned her soon-to-be ex-husband was a pedophile. And that was preparing for the documentary Netflix would eventually make about him.
So we're describing that video, not replaying it. It's a real, dated, verifiable public post, consistent across NBC News, Fox News, and multiple Oklahoma outlets, not a rumor. But it was also her own characterization of an allegation that had already moved to federal review and was never adjudicated in open court. Exact follower counts vary across outlets. We're not stating one on air. So on the night of July 23rd, dispatchers received a 911 call from the home. They heard a woman screaming, then what they believed was a gunshot, and the line went dead. A short time later, a juvenile called 911 separately and said his stepfather had shot his mother. Police arrived and found both Sarah and Duffy dead of gunshot wounds. Investigators determined Duffy shot Sarah before turning the gun on himself. In direct violation of the active protective order, the child was taken into protective custody and released to his other parent, who was not involved in the incident.
Sarah's ex-husband, Lyle Landers, told People he'd spent 5 years trying to get her to leave Duffy. His words, quote, I had begged her for 5 years to get away. I had begged her for 5 years to get away from him, end quote. He said Duffy seemed to have some kind of control over her, and she couldn't seem to break free.
So what I think jumps out the most isn't any single filing. It's how many separate systems this cross and how quiet a jurisdictional handoff can go from the outside. So state protective order system, local police, and then a federal referral that, as far as the public record shows, produced no visible outcome before this happened. Each handoff is a place information can stop flowing to the people who need it most.
The piece that should trouble people is the firearm surrender language attached to that very first 2021 order. Surrender requirements only work if compliance actually gets checked. I don't know whether that happened here. Nobody's published that, but it's the kind of thing that needs verifying before it needed, not after.
So Duffy is deceased, so he cannot now be criminally prosecuted over the allegations that were under investigation. There's no trial, no verdict, nothing left to adjudicate on the state or federal side. If new documents surface, we'll bring them to you. With that, we thank you for being here. That's everything we're tracking tonight.
Follow us on TikTok, subscribe on YouTube for the full replays with chapter markers. And if you want to support, please do, because we need some more equipment, some upgraded equipment to bring you the show that you deserve, honestly. Support the show directly. We're on Ko-fi, Coffee, and Sticker Mule. Links are in our bio.
We'll be back Friday. Headlines end. The details begin. We will see you Friday night.
Good night.